plan for how we're going to present things. Um, I think you said your assistant was working on some slides or slide decks for some of
She,
these.
she did the ADUs. We would need to do the others still, but we're planning on getting working on those.
Okay. Are these all up in the folder in a final draft form?
The posted zoning bylaws are on our webpage under the planning board, and to the left, you should see a green link that says 2025 zoning bylaw proposals. And there should be the 7 bylaws within that post.
And you were gonna pass these around to other departments. Did you get any feedback on
I
these?
haven't yet, no.
Okay. And do we expect to have any of that before? So our next meeting on the 26th is going to be our hearing for these.
Yes, that's when the hearing's open. We don't have to render a decision that evening. So my suggestion would be tomorrow evening. I'm just doing a presentation on the placeholders to the select board. They're going to refer it back to the planning board as is required for zoning bylaw amendments. And then we'll open our hearing on the 26th. And they've scheduled us on their agenda to discuss the bylaw items with the select board on the 27th.
Okay. So you don't need me to be on tomorrow's meeting, but I can certainly come with you on the 27th one or show
Okay,
up for that one.
that'd be great. I know Eric said at our last meeting we typically go to their meeting and just answer
Yep.
questions and give a brief summary of what our bylaws are.
Yep. Just
The
quick
memo
overview.
I presented, I forwarded to the town administrator with the intent of forwarding to the selectmen as placeholders is also within that tab um, as a summary sheet.
All right, say that once more. Oh, oh, I see the
Yeah,
summary.
yeah,
Okay.
yeah. It just gives a brief overview of the proposed
Oh,
change.
oh, perfect. That's great.
Pam,
Okay.
did the enhanced phosphid bylaw go out to the Conservation Trust?
No, I didn't get them distributed in advance as I had hoped. I haven't been in much since our last meeting, honestly. Um, so I will get those out to everyone.
Okay, thanks. Sorry you weren't feeling well.
Oh, thank you.
Yeah, so I don't know if there's anything that we really need to cover on these tonight. Um, I
We
mean,
just procedural wise, if just everyone's aware, those are what's posted. We can amend those and take in recommendations and adjust them as we see fit, as long as it's with the intent of the bylaw, and then finalize anything that comes about through the public hearing process to forward for consideration on the posted town warrant. And then that's typically final. It's much more difficult to amend anything related to a zoning bylaw proposal on the town meeting floor.
Yes, to be
I just
avoided.
Yes, to be avoided as best as possible.
I dropped the link for those into the chat
I
if
just saw it.
anyone needs to see it. Okay, so Pam, nothing else that we need to sort
No,
of.
we hadn't discussed the sign bylaw, though. I think you knew it was
Oh, right.
coming.
Yeah,
Yeah.
yeah, yeah.
Have you got that? Can we put it up and just briefly
Sure,
walk?
sure. Just give me 1 second. So this is the intent of this is to replace the existing sign bylaw. It's actually under jurisdiction of the select board. So every sign that's proposed in town has to go before them for review at a public meeting where they render a decision. The requirements in the existing bylaw are a little vague and have often required a lot of interpretation. So we've tried to require clear requirements, and also for signs that are proposed which satisfy the requirements stated in the bylaw, it's written that they would be able to apply for a sign permit. And if it's determined by the building inspector that it satisfies the bylaw requirements, then they can just be issued a sign permit without having to go to a public meeting. If a waiver is required from the bylaw, then it would be required for them to go to a public meeting and have a decision issued by the select board.
Did the size of the sign, allowed signs change with this?
No, that was all kept consistent with what's allowed, but there was no restrictions on the number of signs that were allowed per building or per lot. So that was clarified, one per business on the building, and then one freestanding sign per lot. And that's in the limited business, and industrial zones.
Does this include political signage? Just out of curiosity.
We're not allowed to call out political signs, but we treat them as a temporary sign.
Mhm.
And we allowed one per lot for a period of 30 days.
Got it.
I had it in there, and then I think there's been a more recent court ruling that said you can't call out political signs. It's a freedom of speech violation.
Just out of curiosity, where does it say that they come to, well, they don't come to us, but it's just, where does
I'm
it
sorry,
say
what
that-
was the question, Mike?
so then now that they don't have to go to the select board except for waivers, where does it call that out? Just that
It's in the first paragraph.
oh, okay, so building inspector, basically,
Mhm.
sign permit, building inspector,
Right.
okay.
Right.
Do we have to call out fees, or is that already taken care of somewhere else?
I wouldn't suggest including any fees in a bylaw, because then you have to go to town meeting every time you want to amend a filing
Okay.
fee. They set their own fees and can still continue to do that.
Oh, perfect. And select board was okay with losing this power?
They haven't reviewed it yet, but it was my understanding that was the preference, not to have to review every sign that's put forth in the town.
That worked. And floodplain district, I know you talked before, you don't think there were any changes to it, right? But you
From
had
the
done kind of
model, from the,
from the
No,
existing maps?
we're replacing it in its entirety, and there are some slight changes. I met with the DCR floodplain manager yesterday, and she sent me PDFs which outline all the changes. So I'll get those posted to the website on the floodplain bylaw page.
then-
They're very minimal, but she had a layer that was provided by FEMA, which overlays the two districts and then highlights the areas that have been amended, and it's extremely minimal, maybe a few feet.
Okay, but you don't
In
think
one
it'll
direction
affect
or the other.
anyone? Yeah, but
No,
you
it
don't think
didn't
it'll
look like
affect any?
anything new would be incorporated.
Okay, perfect.
And again, that's only we're revising the entire bylaw, and FEMA is adopting a whole set of maps with the new date, but the only thing that was amended was the area of Bolton and the Nashua River watershed. No maps in the southern portion have changed.
So the ADU bylaw is fine, scenic road, again, we're just changing names on that. Floodplain sign bylaw.
Pam, out of
what's the site
curiosity, is the
plan?
20-foot setback for the sign bylaw consistent with the current one?
Yes, that was taken from the current one.
Okay,
So, you did include the site plan review, so we take that over directly from select board, so they don't have to just refer those to us anymore. They come to us directly.
Yes, that seems so. It's set up. You get the special permit, and the select board gets the site plan. All special permit developments that are new require a site plan, so it created sort of just it. This will consolidate it and save time, because I think historically, at least from my knowledge, the select board have just referred it to you for jurisdiction and vote.
No, I
So
think
it
that makes more
seemed,
sense.
yeah, it seemed to
Yep.
keep it concurrent was the best way to move forward.
Yeah, I mean, I think that was just from a time before the planning board existed, and that was just what,
The
you
leftover
know,
thing.
a task that they had that no one ever updated.
Um, external illumination of signs is allowed by spotlight. I don't know if you want to look at that anymore. And we define better what's a sign: painting on side of buildings, windows, that type of thing is all included in here.
And again, this would only affect new signs, nothing retroactive, right?
Right.
just go back to the page prior to this. Did I notice side lot clearance? No, go down.
There, it's
Okay.
just a, I'm sorry,
No, go ahead.
for freestanding,
Yeah,
no, there is no side.
okay, that's fine. No, I'm I'm in the middle of an interesting situation with the new Zeka land that the trust bought that are putting a trail on. And the width of the access to the trail is such that we've got to make the sign narrower. And the fact that we have to set it back 20 feet means that we now have to go for a permit to bring down the trees so you can see it.
Oh, I would,
Unintended consequence.
would it be better to place it closer to the road pavement and ask for a waiver?
Yeah, I'll talk to the guys who, well, I just carved and painted the sign.
Oh,
So I have skin in the game on this one.
Drew sent that application in for the scenic road, so I'll ask him about that.
Yeah, I mean, if we didn't have to cut down trees and move it a little closer, that would be nice.
Okay, I think we've talked through the phosphid and the cottage overlay, so those should be
Yeah.
all set. So we'll have to talk about, I mean, we can do it when we get closer about presenting these at town meeting. I'm happy to present most of them. Happy to have someone else take a couple of them. The less non-contentious ones, although I think they'll be okay. Okay, let's see. So street acceptance for Goose Pond Path. Any update on that, Pam?
That's something that's, so we should, oh, the open space 3 parcel, which the board approved, is in the process of being transferred to the Conservation Commission. There is one other issue with security of an affordable unit that was supposed to either be constructed or security provided. I think a proposed mixed-use development at the corner was discussed, and there was mention of an affordable unit being constructed to apply with the inclusionary zoning bylaw within that development. That hasn't moved forward, and the security for the affordable housing unit that was provided has expired, so the developers wants to extend that. And hopes to include the affordable unit within that mixed use development in the future.
I don't know. What are your thoughts on that?
I think we'd have to word it. We can't tie it to the subdivision. Once we accept it, that it'll be basically closed out. So we have to ensure that we get the appropriate security to ensure that that affordable unit is either provided, there's a payment in lieu of given to the
Yeah.
town.
I think we need to have hold on to some sort of a bond and not just.
Yeah. And putting that in the mixed use area is speculative pending a zoning change, right? Or a variance.
I'm not sure what his proposal is at the moment. And then if he would to go the 40B route, if he would
He can't do that anymore,
consider that. What's that?
right? He can't do that anymore now that they've started construction on the apartment, right?
It would have to, you can still file one. You take a chance. I don't think it's likely. Once you achieve your 10%, and there's negative action taken by the town on the comprehensive permit, you can't go to the Housing Appeals Committee. You have to go to the land court, which is a much lengthier and costlier process.
So as Mike said, then the safest thing to do is to continue to hold a bond for it.
Or get payment in lieu. Yeah.
Right,
Yeah. I mean, payment would just be preferable
at the
at this
moment.
point. Yeah.
I just don't know
Um,
how likely that development is to move forward. So we just
Well,
have to
and-
make sure we keep tabs on
What
the
would be
security.
the size of the payment?
I think it was for 225.
Like Bob said, I think that whole mixed use development was contingent on a zoning change at that intersection. So there's definitely no guarantee of that.
But that
basically-
is something that we ought to look at.
I think we're all for it, but we can never, right? We can never guarantee it. Because ultimately it's the town that needs to decide on it. But yeah, I think the point was to try to bring that into the village overlay for mixed use.
Yep.
Which makes sense for that area. I think that would be a good idea.
Yes.
So, okay, can we do street accept? So the subdivision is still open, correct? I mean, we haven't really heard from these people in a while. Maybe they're talking to you. Or I guess they are talking to you.
Yeah, I have an as-built plan. I haven't received certification that the stormwater was built in compliance with the calculations. So we're still waiting on that. We have the security of the affordable unit to take care of. But I think other than that, the subdivision's in pretty good shape.
Yeah. And has DPW gone out and done any inspections on the road?
Yes, they've gone out a few times and actually last fall, in hopes of a special town meeting, the applicant went out and conducted some improvements to the detention pond and the like. So it's just a little difficult to get out there in the winter during snow cover to inspect
Yep.
those things, but it'll be done as soon as the weather permits.
Okay. Okay, so that's any other comments on the proposed bylaws for 2025?
None for me.
Okay.
All right.
I guess we can approve some minutes while we're here.
Yeah, we went a little out of order by accident. So we have January 8th and January 22nd.
Okay, yeah, so we can do the,
We can do the
Um,
8th.
yep.
Um,
so I'll make a motion to approve the planning board minutes from January 8th, 2025.
Seconded.
Second.
Michael Gore.
Aye.
Austin Groner,
Aye.
Bob Romer,
Aye.
Michael Lau.
Aye.
The minutes are approved for January 8th by a vote of 4-0. And then we don't have a quorum for the 22nd.
We have 3 of us, that's not enough?
No, we need, oh yeah, it is, sorry.
Yeah.
I will make a motion to approve the planning board minutes from January 22nd, 2025.
Seconded.
Michael Gore,
Aye.
Bob Romer,
Aye.
and Austin Groner.
Aye.
The January 22nd minutes are approved by a vote of 3-0.
Pam, one thing I did want to talk about is term expiration. And just to clarify who is up this year and to make sure people are going, like, on the website, I think, like, it says my term's up at 2025, but I'm 2027.
No, Bob, I think you're up.
Yep.
We have one more.
Is Austin's term up because he
Is it-
took over someone else's?
I think mine was a 5-year, from when I was elected.
You
Um,
you got elected, so you have a 5-year term,
Right,
Austin.
right. Mhm.
Mike, I think because you got appointed, you are filling out someone else's term, and so whenever
I
that
think,
ends,
yeah, I think, let me look, I can check.
just double check on that, and then we can make sure, because town caucus is coming up.
Yeah,
beginning of
March 3rd, I think.
So you gotta put your name in if you want to go back.
I know the town clerk contacted everyone who was expiring already.
Okay.
Did she reach out to you, Bob?
Yes.
Yeah. So she reached out to everyone who needs to be renewed.
Yeah, I was not included as an incumbent because I was appointed.
Oh, you were appointed also. I didn't realize that. Okay. I thought you did I thought you caucused one year. Maybe not. Okay. Either way. It looks like we have someone from agenda item 1 here. Ms. Croha, is that how you pronounce that?
Yes, hi, good evening.
Hi, how are you? So
Good.
we'll jump back to this. This is request for release of lot from covenant. This is lot 78A from CME. So this is kind of an unusual request. And I can have you speak first if you'd like to. I think there's kind of a number of issues with this request, but you can go ahead and introduce yourself and say what you're asking for.
Sure, thank you, and thank you just first off for accommodating my schedule issues tonight, but
From
my name's Kim Croa. I'm an attorney with Baker Braverman Barbadoro, and I represent Fitzwilliam LLC, which is an entity that purchased this this lot from the town. Actually, it was a tax taking, and Giuliano Fernandez is here also on behalf of Fitzwilliam. So the reason for the request, and I do understand it's a little bit unusual the way that it's laid out, and I think just based on the history of the subdivision, there's a lot of different unusual things, considering that it's half built and has had a lot of history, obviously long before I've ever taken a look at it over the past several months. But just going back, so my clients purchased the Zero Mill Pond, the tax lot 135, which is lot 78A on the subdivision approval. The lot separate from the subdivision is undersized and doesn't meet all of the dimensional aspects of the zoning requirements that would be applicable there. The lot was created lawfully through the subdivision, but the subdivision was created back in 2007. So the original approval did have a timeline on putting in some of the infrastructure for the subdivision, and it was actually 2 years at that time. But from looking at the documents that have been recorded with respect to the subdivision, the planning board has more or less waived that requirement over the years as different lots have come online and there's been releases of those lots as the I guess the subdivision got closer to where the lots were located and people were able to get building permits and build the property on it. So this particular lot is on the far side of where the subdivision is. So it would be the half of the subdivision that's been created and built upon, and then sort of an undeveloped area, and then this lot. And so part of the background for the request is that the lot does have frontage. It has 216 feet of frontage on Century Mill Road. And so it does have direct access to a way, and it would be able to have utilities separate from the subdivision. So our request is being made under a particular provision of the 2011 covenant. There's a paragraph 3 in that covenant that says that owners of foreclosed properties can receive a release from the covenant to build on a land as long as ways and utilities are provided. So we're seeking a release under that section instead of a section that's more applicable to the original developer or somebody else who bought through them, which is separate from our ownership, which came from the town's foreclosure of a tax lien of that particular lot, and then our purchase and payment of funds to the town in order to buy that property. So I can understand where there may be some hesitancy, as you don't want to sort of help developers not abide by the subdivision approvals that they asked for and received. But this is a little bit of a different situation, really quite a different situation, considering that the town did go ahead and foreclose on the tax lien for the unpaid taxes and then put the lot up for sale. And now my clients are just trying to build a single family home on it.
Okay, thank you for going through that. So for the board, so this is a lot that abuts Century Mill Road. So it's in the, I forget if that's phase 1 or phase 3 of the CME plan. And what the applicant is asking for is to essentially release that lot from the covenant and almost treat it like an A&R. So I don't think, so I don't, I think there's a lot of concerns with it. The first being that the lot is part of a subdivision. It's part of a, approved subdivision plan. The subdivision is currently in, basically all their permits have expired. The developer has, more or less walked away from it. There were 4 phases to this development. Phases 2 and 4 have been built. Phases 1 and 3 haven't. So there are many lots in phase 1 and 3 that are owned by individuals who are in the same situation that you are. The applicant is essentially asking that rather than treat this lot as part of the subdivision, they treat it like a typical, parcel, not within a subdivision, and trying to have an egress driveway onto Century Mill Road. So that's kind of the first major point. I don't believe we can take, I mean, the lot was designed and is on the plan to be serviced from a non-existent road at the time right now, but not served from Century Mill Road. So I think that's kind of the first problem. The second problem is because it's a lot within a subdivision, it's only about an acre and not the 2 acres that a typical lot would need to be built on in Bolton. In addition to that, there are a number of easements and restrictions on that lot that are part of the subdivision. And those would have to be removed in order to do anything with it. So the kind of that's sort of a lot of separate reasons. The main reason that I think there's a problem with this is basically that the subdivision is kind of in limbo at the moment until somebody comes along and finishes phases 1 and 3. I think it sets kind of a not great precedent to so first off, let me step back and just say we are releasing no lots and issuing no building permits in the subdivision anymore. The developer owes a significant amount of money for affordable housing units, and they've gone over the limit that the planning board allowed them to issue. So there's really kind of a lot of problems with doing what you're asking for. So let me pause there.
Yeah, and I think if you okay to jump back in, I could address a couple of the points. More specifically as they relate to the easements and other aspects affecting this property for the benefit of the subdivision. Those easements are easements of record, and they would remain on the property if the property was released. We would have to site the house and the access in a way that preserves the intention of those easements. While if they need to be relocated, which I don't believe they will be, but that's something that would be considered. There is a right to do that as long as they preserve the intention. That's a state law aspect of being able to relocate and move things as long as they allow what was initially done. So if the board were inclined to release a lot, which I hear what you're saying, but you know, if it were, it wouldn't be a release to the detriment of the remaining lots in the subdivision. There wouldn't be anything with releasing this particular lot that would make it more difficult for somebody to come in and build the rest of the subdivision at some point and honor the commitments of the original developer, whether that be the same person or a new company or whatever that looks like, I don't know. But it would be a way to allow this lot to get productively back online and earn the town money and build in a way that would facilitate the intent of the subdivision with the access and the ways, but not get bogged down in the developer's lapses and finishing where he was at.
Yep. No, I understand that, and I do, you know, obviously we would like something to be built on it. I do think it sets a bad precedent if we start granting approval. So if someone were to purchase some other property or reconfigure property and say, oh, I want to put a common driveway up the side of this now and service these other lots, and then came to us and asked for a similar thing, I think we'd have a hard time saying no to that if we approved this particular request. So that this is sort of my, you know, my interpretation of it is that this lot is part of an overall subdivision. It's unfortunate for everybody that the subdivision has been bogged down the way it was, but the intention for not only, you know, the applicant, but for everyone else who owns property in those phases is that someone will come along and construct the road and make these lots be serviceable at some point in the future. Pam, do you want to add anything to what I've said?
No, I agree with you, Mike. Unfortunately, and there's also a 50-foot tree buffer that was required along the front of Century Mill Road. So that is part of the approved subdivision plan as well. It runs 50 feet along the entire length of the frontage. And now a large portion of that was removed by some construction that was previously conducted. It is required to be restored, and it would be my opinion that that would have to be amended as part of the subdivision approval to allow for a driveway to be located within that buffer.
Can I also ask another naive question? So, I guess the town, when it foreclosed on the land, it sold this one unit. Is that, sorry, this one lot of land, is that right?
It did a numerous auctions for, I'm sorry, it didn't auction, the town conducted an auction on tax title property for numerous parcels throughout town. And this was advertised as likely non-buildable as part
I
of that
see.
process.
I see. Okay, I was curious about the conditions upon which it was sold.
Part of a tax auction. So, you know, again, just to be clear, there are a number of lots further, I don't know if it's south of this, that, you know, other owners currently are sitting on, waiting for some movement on the subdivision. So, you know, this lot was not unique in that. You know, I understand the notion that the new owner says, well, we have frontage on the road and therefore we don't need the other road. But, you know, again, it would be my contention, and I welcome other opinions from the board, that this lot, you know, was created as part of a subdivision, and it was meant to be serviced by a road, you know, to be built off of Century Mill Road, and not a standalone driveway.
That's a question. I would like to add something there. When we did bought the
Can you please
lot,
identify yourself?
Giuliano, I'm manager of Fitzwilliam.
Okay.
LLC. When we bought the lot, that was not what the marketing or the situation that the lot was sold. It was very explicit that it had a frontage on a Central Mill Road, even though it was part of the subdivision. There was the headline on the title, selling the lot. You know what I mean? Every lot that was sold was some different description, selling the lot. But on this one particular lot, it was, you know, enough frontage on Central Mill Road, but still part of the subdivision. You need to go through the process. You know, and speaking to my attorney, when we purchased the lot, was that when the subdivision was made it, the town made some concessions just in case the subdivision didn't work and didn't move forward. This law in particular had enough frontage, but didn't had enough lot size to comply with the requirement. We understand has some easements in there. We had the engineer look at, you know, how to work around those easements so we can build a house in there. I don't think that's an issue. More now is the issue is part of the subdivision or not, but we, you know, again, rely on our attorney to, before we came to the planning board, to make sure we had a legal right to take that law out of the subdivision. And I did some homework on the subdivision, and as far as I understand, unfortunately, is so much other problems going on with the subdivision that I don't expect that subdivision to be in compliance anytime soon on how much they gotta, how much work they need to do to finish that road. There's so much ledger there, so much, you know, side work that needs to be done, that I don't think, as you know, all the other lots are gonna be able to make enough money to the developers to take over what's left on the subdivision. So, you know, the town just got to think about that too, I guess.
No, I understand, and I understand you're in a tough position with this. You know, as far as what happens with the rest of the properties in the subdivision, I honestly don't know the answer to that. Like once a subdivision, you know, approval process has gone through, I don't know what the process for amending that is. I mean, like I said, a lot of people own parcels of land in this, you know, and would eventually like to, you know, have their houses built on it, or you know, see some financial gain from that. So I'm not positive what happens if, like I said, certainly a new developer could come in and try to work it. I don't know if it's possible to reconfigure those parcels at some point. That's sort of beyond my scope of this. But for now, this, as far as I'm concerned, this parcel is part of an existing subdivision that faces a lot of issues, and we cannot, release it from the covenant right now.
I do agree with you as part of the subdivision, but I don't think we can dispute the fact that we have enough frontage on a Central Mill Road.
Yeah, but the parcel was never intended to have a driveway going out onto Century Mill Road. And so a good example would be like if you did build a driveway and then at some point in the future someone finishes the road that's there, you may be too close to that road where your driveway is. Right? Everything was designed with sight lines, and the plan was designed the way it is with a road there and not a driveway.
Respectfully disagree on that. We got almost 200 feet of frontage.
Yeah. So, I was just gonna say that the subdivision plans don't show the driveways and the layouts and the different things. And while I do appreciate that the difference in the different lots, I do think that this is truly unique from the other properties because it does have the frontage. 200 over 200 feet is a lot of space to accommodate a driveway in a way that isn't going to interfere with the road or anything that gets built there. There is what looks like a dirt way going out along the side of there from looking at aerials overlaid with where the plot plans are. And I can pull up the covenant itself from 2012, but the paragraph 3 says, as far as having lots be pulled out, notwithstanding the foregoing, a mortgagee who acquires title to the mortgage premises by foreclosure or otherwise, and any succeeding owner of the mortgage premises or part thereof may sell or convey any lot subject only to that portion of this covenant which provides that no lot be sold or conveyed or shall be built upon until ways and utilities have been provided to serve such lot. So there is a specific provision in the covenant that we're seeking relief through. It's not a general release that could be used by any particular owner who bought hoping that the road would be continued, and it wasn't. It's just a different situation, and it's a protection that was written by the board into its own approval documents to be able to give relief to somebody who took a property completely separate from the development. This wasn't purchased through the developer or any gain to the developer. It was the town who received the gain from this purchase.
Yep, I understand. I mean, as far as the normal subdivision process, we release lots out of the covenant essentially when they meet certain criteria. And the paragraph that you're citing, I don't think was ever meant to say, like in this case, the fact that the developer owes, a significant amount of money for the affordable housing unit, as well as other issues in the subdivision. Regardless of that paragraph, we would not release any other lots. We would not issue any other building permits in the subdivision until those issues were taken care of. Right. And I again, I kind of go back to, I think you're trying to treat this like more of an A&R lot and not an actual lot as part of a subdivision that's controlled by the overall covenant.
What doesn't meet the requirements of an A&R.
Regardless of the conditions of the subdivision are still applicable to the lot, whether we can release it from covenant or not, that there are significant violations with that approval. So I think that's an issue as well. And again, there's a 50-foot tree buffer that was required along Century Mill Road.
I'm also worried that this is not a unique case. If we take a look at the other lots that are still outstanding, there could be other lots that also meet the same criteria, which to Michael's point would be setting a bad precedent, I feel.
And I think there's only one other lot that would be in this situation, and that's lot 1A, which is the only other one that has frontage on Century Mill Road. All of the other ones are all internal. And I don't know offhand who the owner of that lot 1A is, but the other lots would just, the same reasoning wouldn't apply.
I still think if someone wanted to create like a common driveway at the end of the existing Mill Pond Road, that I think they would then find themselves in the same situation as this.
Maybe, maybe not, but it's certainly different. I mean, the location of the driveway wasn't included on any of the plans that I've been able to find online.
No, but the
And-
driveway, I mean, there's no disputing that the driveway for this lot would have been serviced from the road that was going to be constructed. It is part of a subdivision.
Disagree with that. I think the subdivision has it's all depending on how the site it works. You have a very drop in elevation from the lots there internal from the street. If you ever drove to that side, you see how much drop you have. So make no sense to have actually a driveway from the subdivision to the internal lot, counting at that drop on elevation. So
Sure, but if the plan had been to service that lot from Century Mill Road, that the curb cut would have been shown on the definitive plan, and that wasn't the case.
Not necessarily. I mean, it could have been, but they wouldn't have necessarily needed to do it.
No, I mean, I understand. I feel bad. I think this is in a tough situation. The board can think on it a little bit if there's some other way to make this work. But this subdivision has a lot of issues with it. And if we start releasing lots here and there, I think we're going to make things worse. So I'm not in favor of doing that.
What I might suggest is that if we, hearing the feedback from the board, have an opportunity to go through the prior subdivision approvals and the covenant in more detail, and perhaps propose a list of conditions for the board to consider. And if the board still says we're not releasing it, then that's that, but at least have the opportunity to do that and for the board to take a look at and see if it's something that could work for everybody.
Yep, we would be receptive to hearing that. And just to be clear, because the lot, even if we approved everything, because the lot doesn't meet dimensional requirements, you would still have to go to ZBA to get a variance on that. Right? It's a 1 acre lot as opposed to a 2 acre lot.
Well,
And that would set a serious precedent.
if it's part of the subdivision, it was a lot created by the subdivision to be undersized. So
Yeah, but see, there we go.
Yeah, for the
I mean,
subdivision.
it's either part of the subdivision or it's not part of the subdivision.
well,
So I mean,
it's
you can't
certainly
have it
part of-
both ways.
No, it's certainly part of the subdivision. I'm not saying it's not part of the subdivision. I mean, if we can't get relief here and we go looking for a variance, that might be something different. But the purposes of this request is acknowledging that it's part of the subdivision, but asking for a release under the covenant provision that allows this lot to be constructed on without the rest of the subdivision being completed. But I'm not disputing it's part of the subdivision, and we need to accommodate some of the requirements that are both subdivision requirements and association requirements that also burden the lot.
Understood. So, I mean, if you guys, go back, review, kind of resubmit what your findings are, and I'm happy to continue the conversation another time.
Appreciate that.
In the meantime, Pam, do you need us to make a motion on this?
Yeah, Kim, if you want to submit a written request, or Giuliano, either one of you, just to allow continuance of this to the next meeting. So it's clear that we have gone beyond the 45 days with mutual agreement. That would be helpful. And if the board could vote on that verbal request tonight at the meeting, we can schedule it at a future date.
Sorry, what are you asking the
I-
board to vote on?
A request to put it at a future meeting for the board's vote would be the best way to go.
Okay. I will
We have
make a
to
motion.
act on it within, I'm sorry, we have to act
Oh, no,
on
no,
it
no.
within 45 days of the request. So I just want to be clear. Kim has already granted one extension beyond that time due to scheduling conflicts. So I just want to keep record that it's been a mutual decision to continue it.
Yes, and I'm happy to follow up with that email.
Thank you.
I will make a motion to continue the discussion of lot 78A from Century Mills Estate to a future planning board meeting.
Second,
Michael Gore,
Aye.
Robert Romer,
Aye.
Austin Groner,
aye.
Michael Lau.
Aye.
Okay, items continued by a vote of 4-0.
Okay. Thank you, guys.
And do you have a
Thank
date
you.
for the March meeting? Or should I, Pam, should I follow up with you separately? on the meeting?
It's scheduled for the 12th and 26th of March. If that changes, I can let you know, Kim.
Okay, great. Thank you very much.
Thank you.
Have a good night.
You too.
Okay, other business. Anything else, Pam, that we need to review?
No, I don't have anything pending, just as an FYI. Orchard and Oak Tavern is proposing to be located at the Baba Sushi Restaurant site at 544 Wattaquatic. The hearing with the ZBA has been scheduled for March 3rd.
Orchard and Oak?
Orchard and Oak is the name.
It's a tavern, you said?
Yes.
Restaurant, right?
They got a menu out yet?
Not yet.
None comes up when I Googled that, so.
So they'd be allowed to go in and utilize the building as is, but they're proposing to relocate the existing deck and provide an outdoor seating patio. So that change requires an expansion or change of a non-conforming special permit from the ZBA.
I've got one. So the environmental pools building. So I saw a sign up that they're putting a gym in there. Do you know about that?
Yeah, that's a proposal to put a gym in, yes.
Is that allowed by right? I mean, so they came in to us to put in like a interior design shop as part of that with the notion that that was similar in use to the existing pool business, that it was help you design blah blah blah. I have no
Yeah,
real
they came in
Go
for
ahead.
3 uses, all required for special permit. I can't recall exactly what the 3 were. One of them was not a gym, but they were all special permit requirements. And the board voted that it was an insubstantial change.
Yes, but
So-
I mean again, not that I'm against having a gym there, but I just don't remember that being one of the uses. And is that allowed?
This falls into the same use category as not the same use category. It's a special permit as the other 2 were. Now I think one of the 3 uses that was previously reviewed by the board is no longer locating in the building and is being replaced by this gym. So they provided a parking tabulation to show they had sufficient parking within the existing building.
And do
And
they
I
need
can-
to come back to us for a special permit for the gym use, or?
The way we did, I didn't get, the building inspector and myself discussed it, and we didn't think it was necessary just because the board had approved the other uses as an insubstantial change, but I can certainly put it on as an agenda item for
No,
your
I mean,
review.
I trust your judgment. I mean, if I imagine it's gonna be something on the small side, not like a Planet Fitness sort of place. So as long as they're
Right.
parking,
Yeah, it was 2,000 square feet, so I believe it was 2,000 square feet. I'll look at the permit and so we requested a parking tabulation for all the uses within the building, and it satisfied that, and they're not doing any changes to the exterior of the buildings. So it was felt that it fell within the existing approvals, but I'm happy to bring it before you at a
no,
future agenda
I
item.
don't think you need to bring it before us. I was just kind of curious because
Okay.
anyone else have things they want to talk about?
I just had one quick one. There seems to be an interesting like optional provision in Chapter 59, Section 50 of MGL that I kind of came across. My mom is actually in the Board of Assessors for her town in Egremont, Massachusetts, and this is to essentially, if adopted by the town or municipality, it's actually to promote construction and rental of affordable units, and it's a partial tax exemption incentive. And I think I just corresponded a little bit with Pam about this previously and wanted to see if our town already adopted it or if there's potential for us to use this as a tool to incentivize that kind of construction. So I just like post a link here for those who want to take a look at it, but I'm not sure if this is something we've talked about. I know the distribution of taxes in Bolton is a kind of a sensitive topic. But this is just an idea that I wanted to bring to the board, so we can take a look at what other towns are doing to incentivize things like this.
Thank you, Austin. Sorry, I haven't had a chance to discuss that with the town administrator yet, but I certainly will.
So what is it? It's a way of reducing property tax for affordable housing for individuals,
Yeah.
is that?
Essentially, so there's obviously some limits, so you can't get a tax waiver for more than what the property would otherwise pay.
Mm.
But it's like a fractional exemption. So if you build an ADU and you rent it, to somebody who has a certain income level for the whole year, you get, I guess, you take the square footage of that affordable unit relative to the total square footage on that property, and you get essentially a tax exemption of that fraction if you can prove that you're renting it out to those people.
See. And so in that case, the ADU isn't considered affordable, but the fact that you're renting it out qualifies the owner of the house for some sort of a subsidy or rebate.
Yep, exactly. Yep.
That's interesting. I mean,
Yeah, I thought about this as maybe, Eric mentioned if there's some additional incentives we could provide to incentivize within the cottage district to have affordable units built and rented to people with certain income levels. I wonder if this could be something that would get us there.
so the cottage will have its own affordable requirements just as part of our the inclusionary zoning bylaw. So for every 8 or whatever, one of them has to be affordable.
Right, but that's affordable in the sense of the unit. I guess
Yes.
these are additional requirements having to do with the income levels of the people who either rent or buy there, I believe.
Yeah. Yeah, that I don't know much about. But maybe Pam, you can do some research and
Yeah, I'll do some research. I
Bolton.
had told Austin I would speak to the town administrator a while ago, and I just haven't gotten to that yet.
Mhm. Yeah, it was just recently passed by Egremont, Massachusetts, which I think is roughly about a third the size of Bolton. So I don't know that taxes are as sensitive of a topic there as it is here. This something like this just may not fly in Bolton because what we're asking is essentially to shift the burden to people who don't do something like this. So
Well,
I'm
and
happy to at least get the information together. I know that deed restricted affordable for sale units are taxed at a lower rate. it's reduced proportionately to the purchase price of the units, so they are getting a tax break in that sense, so I will look
Mhm.
into this more and also speak to our assessor about the provision.
Sounds good. Thank you.
Okay, thanks for bringing that up, Austin.
Sure.
Anything else that people want to talk about?
No, I think we have to be extremely careful about this discussion on CMI. I see this as,
No, CME, yeah.
I mean, it's sort of contradictory in a way that we're trying to get the best of both worlds. Take something out of a subdivision and then keep all of the regulations and requirements consistent with those that were part of the subdivision, yet make it a separate lot in the brave new world of A&Rs. And that, to me, that's an amazing precedent.
Yeah,
Yeah, it's still subject to all conditions of the subdivision, even though it's at a corner.
yeah. I
Yep.
mean, I would feel bad if it was, if the lot were advertised as, frontage to build on, but I know, Pam, you said it was advertised as potentially non-buildable, so. And while it's currently non-buildable because there isn't, that phase isn't completed yet, the hope is someday it will be, buildable when the road's finished. So I understand it's a tough situation.
Would they have been able to come to a planning board meeting with these questions if they were considering buying that piece of property? Would they have tested on this before they bought it, essentially?
They certainly could have talked to Pam. Yeah,
We did have conversation, yeah.
yeah. And did you make it kind of clear that, yeah. So, I mean, it's
A
fine.
risk.
Caveat
Yep.
emptor, But I mean, again, the hope is like that. I don't know if anyone's in the summer. I recommend that it's probably not legal to do, but like go park on Century Mill Road and walk up that back part. I mean, it's stunningly beautiful, that area of the development. And if they ever finish it, it will just be an absolutely gorgeous, area of houses. As he said, that, they ran into a ton of ledge on there. Now, that certainly doesn't mean anything insurmountable, but that was where they ran into problems initially.
And that's where the builder essentially ran out of money. That's the root cause of the problem, or?
I don't totally want to well, yeah, I don't know for sure. My belief is that the 2008 crash kind of, I think, lost a lot of money in that, and that affected things, but I'm not positive. Okay, anything else that people want to bring up? Okay, so next meeting, February 26th.
I started, just for your information, I advertised that at 7 just because the number of articles that we have to address. So I thought
That's a good
getting an earlier start would be beneficial. All right.
Yep, I agree with that. And so again, that will be our public hearing. Is there anything else scheduled for that night, or is it just that?
No, I only scheduled that for that evening.
Thank you.
Yeah,
Unless we get an A&R, that would be the only other thing we'd need to address.
Yeah. Okay. No, that's great. Okay. If there is no other business, then I will make a motion to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
Thank
Okay,
you.
everyone. We'll talk to you on the 26th. Pam, I hope you feel better.
Thanks.
And we'll
Feel
check in
better.
later on.
Have a good
Bye,
night.
everyone.
Bye.
Aye.